there are a lot of risks shifting kind of elements that come into these contracts. And what I mean by that would be things like just simply the liability of what you do day to day for your employer. Some contracts make you personally responsible for the employer's risk when you're working for the employer. Those sorts of clauses are troublesome. Attorney fees are another one. Because many of these contracts will make the midwife pay all attorney fees for the practice if there's a dispute, regardless of what that dispute is. Sometimes not even if they didn't prevail, even if the practice didn't prevail, or if any portion of it they prevailed. So you have three things at play in the argument, and they win one and you win two, you still would, under the contract, owe for fees. So looking at the fees and those sorts of things. Finally, we also always look at the notice provisions that are within the contract, because those are the kind of things that you can just read right over and not notice. Redundant notice to notice, but the idea is that you have to know who you specifically need to tell for fundamental pieces within this contract. We're so used to working for whoever immediately supervises us or whoever is our teammate that sometimes these notice provisions require you to provide formal notice to a third party, maybe a principal member in the practice partnership, ownership, or a specific method. So those are probably the major pieces that we look for in employment contracts, but we also just have to go through and read the whole thing. It's sort of a teamwork approach. While it's not legal advice, there's an awful lot of scholarship about what are in contracts. We're comparing one contract to another. Then finally, what to do with these differences. Because we have seen egregious contracts that we really thought, this potential employer is doing something just outrageous, and our clients go to challenge the contract, and they've actually never read the contract either. They had a cousin that was a lawyer or something, or did some internet searching, found something entitled employment agreement, and then put this out and didn't even realize the unfairness of what they were proposing. So, they believe they have to have a document called an employment contract, which they don't. And if they do, they just need one, and they are all sort of one size fits all. So it's some potential conflict management or conflict prevention that's important as you move through this phase of working on a contract.